You've been involved in your case, life has been going somewhat according to plan, but now you're heading to trial. Now you need to know what to expect when you're actually going to trial. Trial in Texas, or at least in divorce and custody cases, actually happens a lot less than you may assume. I think it's 5 out of every 6 cases that go to mediation end up settling, but just because you didn't settle and you want your day in court doesn't mean that anything is wrong. It means maybe something that's in front of you, at least from a negotiation standpoint, isn't worth it, and you'd rather have your day in court. Completely fine, that happens, okay? Don't stress out over the fact that some third party may be responsible for making decisions for your life. It's a big question to ask a judge, but it is something that may be important to you, and it may be what's in your case's best interest. How does trial actually work? I will say that trial is probably the closest thing to TV lawyering as you've probably seen. In a trial setting, probably similar to a hearing if you've had one up to this point, you will be seated with your lawyer, the other side will be with their lawyer, assuming that they have one, and then we volley back and forth with various witnesses, be that the parties, be it third parties, whomever it may be, and elicit testimony in front of a judge so that the judge can better make the decision for what they should do both for your child, in the interest of a custody case, or potentially to divide up your property in a divorce. If you're making it all the way to trial, it's likely that there's going to be a handful of deadlines that are important to remember. First and foremost, we have to make sure all of our pleadings are up to snuff and ready to go. As the petitioner, that needs to be done 14 days ahead of trial, and as the respondent, the person who is responding to the lawsuit, that person needs to have all their pleadings in order 7 days prior to trial. As far as discovery is concerned, as a reminder, just discovery is exchanging information about a case, be it tangible things, be it admissions, interrogatories, whatever they may be. That deadline typically closes 30 days ahead of your trial date. Now, I'll remind you, if you have a pretrial scheduling order in place, remember the list of deadlines about when and how your case is going to proceed, those dates will override these common deadlines according to the rules of civil procedure. So my suggestion, at worst, is to talk to your lawyer and make sure that everybody's on the same page when these things are supposed to be completed. Going into trial, my suggestion, as you assume, is like anything else. You need practice. You don't go into a game without ever having seen a pitch. You need to make sure going into trial that you know what you're walking yourself into. My suggestion is talk to your lawyer. Maybe have some examples of what cross-examination is going to be like. When you're in front of a judge, you don't want that to be the first time you've ever had to sit down and answer some hard questions. The other side, be it a lawyer or potentially your spouse or the parent of your child, has the ability to ask you a lot of questions, at least under the rules of evidence in a particular way. That person's job, at least to some extent, is to try to trip you up. They want you to sound flustered, they want you to sound mad, irrationally sad, angry, whatever it may be. Try to paint you in a bad light so that they can get what they want. This is kind of how it works. We're gonna have to talk about some unfun things in front of a judge. We're gonna have to talk about some pitfalls in your case. We're gonna have to talk about what has happened up to this point with possession, with access to the child. Have you been paying your support? How has the child been affected by this process? And everything in between. No matter what, you have to make sure you're putting your best foot forward. Now, my suggestion is, above all else, make sure you're doing that well before you ever step in front of a judge, okay? It's very important, at least to me as your lawyer, it's very important that we're going into court with the cleanest hands possible. That means we have done our due diligence, that means we have met our deadlines, that means we have answered all of our discovery timely, and that we have what we need according to the local rules of that court going into trial. Now, as you would assume, trial is trial. Even though I said it before, you are putting your life in a third party's hands. So you need to understand that if you're ready to take that leap and step into a courtroom, it kind of is what it is. The judge is going to hear the evidence, and the judge is going to make their decision based on that evidence, be it tangible, testimony, or anything else. So understand that if you decide to go through it and want to have your day in court, while you're entitled to it, you may not get what you want. But at least you were heard, and if that's what you're seeking, that's perfectly fine. If you find yourself headed to trial, or you think that may be in your future, and you think you need some help, feel free to reach out to us at vergestexas.com, or you can give us a call at 817-203-2220.